Mamie Mitchell has filed a lawsuit against Alec Baldwin and the Russ production set. They, in return, filed a motion to dismiss, and we're going to break that down right here. Miss Mitchell was on the set of Russ when Alec Baldwin pulled the trigger that killed Helena Hutchins. However, she did not get hit by the bullet. She was not hit by the bullet that came from the gun that Alec Baldwin fired. Helena Hutchins and one other individual were hit, and Miss Mitchell was not hit. She was close by when Alec Baldwin pulled the trigger. She has filed a lawsuit for 3 different causes of actions against Russ Set and Alec Baldwin. The first one being assault and battery, the second one being intentional infliction of emotional distress, and the third one being negligence. So how a lawsuit starts out is that a plaintiff files a petition against the defendants. The defendants are then served with that petition, and they have to file either an answer or a motion to dismiss. In this case, Alec Baldwin and the Russ production filed a motion to dismiss. The twist in California is they call it a motion to demur. So what this means is that Alec Baldwin is asking the court to take away these 3 claims because Ms. Mitchell didn't allege the facts that are necessary to prove these claims. Now, in a motion to dismiss like this one, the court has to take all the facts that the plaintiff pled in the light most favorable as if they were true. And so the court will recite facts from the petition as if they are true facts. It is difficult to overcome a motion to dismiss unless there just are not any facts to support the claims that the plaintiff has alleged. The court ruled on Alec Baldwin's motion to dismiss, and we're going to look at it right here. I've already reviewed it, and so I've made some highlights on the important parts that I think we should review together. So the moving parties are Alec Baldwin and Eldorado Pictures. Apparently that's one of his company's motions. Plaintiff Mitchell sued defendants Alec Baldwin and Eldorado Pictures based on injuries plaintiff alleged she sustained when Baldwin discharged loaded gun towards plaintiff. Demurring defendants demurred to plaintiff's first through third causes of action in the second amended complaint on the grounds of uncertainty and insufficient facts. And the judge breaks it down in this written order. We'll scroll down to the more important parts. First, the court addresses the first cause of action, assault and battery. So first, Alec Baldwin has asked the court to dismiss assault and battery. In fact, those aren't necessarily one claim. They're actually 2 separate claims. You've got assault and you've got battery. They're still completely separate. And so the court addresses them separately, even though that they are addressed under first cause of action. In this, plaintiff has agreed to withdraw her claim for battery. She didn't file a motion to dismiss before the hearing, and so the judge took it upon itself to dismiss that claim. Now, Eldorado Inc. is a company. So the fact that they have pled assault and battery of a company, that's kind of difficult for a company to assault someone or to batter someone. And so I assume the judge will dismiss it against Eldorado. And if we look at it, the court will sustain the demur on the first cause of action regarding Eldorado without leave to amend for both assault and battery. The reason being, like I just said, is that a company cannot assault someone. It has to be someone acting on behalf of the company. They don't plead respondeat superior in this case, and so the judge, rightfully so, dismissed the first cause of action, assault and battery, against Eldorado Incorporated. On the cause of action of battery, Miss Mitchell was not actually hit by anything. She wasn't hit by a bullet. She wasn't necessarily hit by shrapnel, and I don't think they even claimed that in their petition. And so that's why the plaintiff didn't even try to argue that there was a battery. And so the court took it upon themselves to dismiss that count, and they move on to the assault. Since this happened in New Mexico, they'll be using New Mexico law. Under New Mexico statutes annotated section 30-3-1, assault consists of either A, an attempt to commit a battery upon the person of another. So did this person attempt to commit a battery upon another person? No. B, any lawful act, threat, or menacing conduct which causes another person to reasonably believe that he is in danger of receiving an immediate battery. Or C, the use of insulting language toward another. It goes on, battery is the unlawful intentional touching or application of force to the person of another when done in a rude, insolent, or angry manner. While assault and battery are closely related, one may exist without the other. And that's important, like I had mentioned. They're technically separate causes of actions. Like this says, you can have an assault, you can have a battery as well with the assault. or you can have assault and no battery, or you can have battery and no assault. So they don't necessarily have to coincide with one another. In this case, the plaintiff is best served under this B, where it says any unlawful act, threat, or menacing conduct which causes another person to reasonably believe that he is in danger of receiving an immediate battery. If a gunshot went off right next to you, you would likely reasonably believe that you're in danger of receiving a battery, of being hit by another gunshot. And so that's the best avenue for plaintiff to go under on assault. I highlighted this in orange and it does not look orange. But the judge goes on to recite some of the allegations in plaintiff's second amended complaint. And we'll see right here, every safety protocol designed to ensure that safety arms would be safely used were ignored, and actions that were taken were against all industry norms, including without limitation, as follows. And they go through Alec Baldwin intentionally fired the gun. Alec Baldwin intentionally fired the gun towards individuals. The gun was handed to Alec Baldwin by the assistant director. And I find this part interesting. The gun was handed to Alec Baldwin by assistant director. Guns are never to be handed to an actor by anyone other than the prop master or armor. I'm not a prop master or armor. I don't know how exactly it's supposed to go on a set, so that's interesting. Mr. Baldwin, being an industry veteran, knew that the gun in question should not have been handed to him by the assistant director. And he also knew that he could not rely upon the assistant director's representation that it was a cold gun and that the gun was safe to use. That makes sense for that to be an industry standard, that only a prop master or armor should hand a gun, a prop, or a real gun in this case, to the actor, because they're the ones that are handling them all the time, and it's the safest way, and so that makes sense. The industry-wide safety bulletin for use of firearms mandates that all firearms are to be treated as though they are loaded, because Alec Baldwin knew guns are inherently dangerous weapons. I assume he's shot a gun before. He's been in other movies where there have been guns. Alec Baldwin, without just cause or excuse, failed to check the gun to see if the firearm was loaded. The industry norm is that there's that industry norm language right there, is that the armor hands the gun to the actor and demonstrates to the actor, in this case Alec Baldwin, that the gun chambers are empty. And in this case, that did not happen. So, for pleading purposes, the court finds that the second amended complaint alleges facts sufficient to establish Baldwin endangered the safety of others by handling or using the subject firearm in a negligent manner, constituting negligent use of a deadly weapon under New Mexico statutes annotated section 37.4. And that 37.4 goes back up here when we were talking about the law for assault and battery. The New Mexico statutes talk about negligent use of a deadly weapon, a firearm. And this is where they come back to the assault part of it, is next in paragraph 82. We're going to skip down here. The gunshot caused plaintiff to experience pain in her ears and head. Shortly thereafter, plaintiff began to hear loud ringing in her ears. Upon hearing and feeling the discharge from the concealed deadly weapon, plaintiff was terrified, feared for her life, and was reasonably placed in that's the important part, reasonably placed in danger of receiving a second immediate battery, specifically of being shot by defendant Baldwin by the way of subsequent gunshot. So the plaintiff alleged that that was a battery, and the judge isn't really buying that, but he is understanding that for the fact of the first part of the claim, the assault part, because Miss Mitchell still thought that it was reasonable that she might get a gunshot at her, and that would be a battery. And so she has that reasonable belief, or the judge is taking it under the light most favorable to the plaintiff, that she could reasonably believe that she would be battered next. And the judge goes on, for pleading purposes, the court finds that the second amended complaint alleges facts sufficient to establish Baldwin's negligent use of the firearm caused plaintiff to reasonably believe she was in danger of receiving the immediate battery of a subsequent gunshot. Accordingly, that goes back up to the statute where we talk about assault, any unlawful act, threat, or menacing conduct which causes another person to reasonably believe that he is in danger of receiving an immediate battery. And the judge, rightfully so, with the standard that they have to use, accordingly, the court finds that the second amended complaint alleges facts sufficient to constitute a cause of action for assault against Baldwin. So the judge went ahead and dismissed battery because the plaintiff didn't try to amend or support her complaint and argue for it on the battery part, and she conceded those facts. So the judge went ahead and dismissed the battery claims against both Alec Baldwin and El Dorado. On the assault side, the judge found that a company cannot assault someone. So it rightfully so dismissed that against El Dorado. On the assault charge against Alec Baldwin, the judge upheld that. Let me know in the comments if you agree with the judge dismissing the assault and battery against El Dorado, and let me know if you agree with the judge on dismissing battery but keeping assault against Alec Baldwin. And we'll move on to the second cause of action, which is IIED, and that stands for intentional infliction of emotional distress. And that is a mouthful. So similar to the assault and battery against El Dorado, on those causes of actions, the judge does the same thing and dismisses the intentional infliction of emotional distress claim against El Dorado because it's a company. It's difficult for a company to have an intent to inflict emotional distress on an individual. So the judge rightfully dismisses that one right here. Thus, the court will sustain the demur on the first cause of action. I think it's supposed to say second. Regarding El Dorado without leave to amend. As it goes to Alec Baldwin, the court addresses that for pleading purposes, the court finds plaintiff's allegations taken together establish extreme and outrageous conduct on the part of Baldwin in reckless disregard of plaintiff that caused plaintiff extreme and severe emotional distress. Just like the court was talking about earlier, all those industry norms, everything that someone is supposed to do when handling a gun, especially on a set, Alec Baldwin completely failed to do any of those, which any one of them could have prevented this from happening. And the court goes on, namely, Baldwin recklessly engaged in extreme and outrageous conduct when, despite being aware requisite firearm safety precautions had been ignored and live ammunition was present on the film set, he unexpectedly cocked and fired a loaded handgun in plaintiff's direction without first confirming it did not contain live ammunition. Accordingly, the court finds the second amended complaint alleges facts sufficient to constitute a cause of action for IIED against Baldwin. Again, let me know in the comments if you agree with the judge on this one, dismissing the count of intentional infliction of emotional distress against El Dorado, but letting it go on against Alec Baldwin. Third cause of action the judge addresses right here is negligence, and this is probably the strongest cause of action that they have. And so the judge addresses it. First, we have to use New Mexico's law on what negligence is. So, to state a negligence claim under New Mexico law, plaintiff must allege a duty owed from the defendant to the plaintiff that based on a standard of reasonable care under the circumstances, the defendant breached the duty, and that breach was a cause in fact and proximate cause of the plaintiff's damages. So there are really four elements like we've gone over before: a duty, a breach of that duty, causation, and damages. And the defendants, Alec Baldwin and El Dorado, make three arguments. Plaintiff does not allege the demurring defendants owed any duty to her. Plaintiff does not plead any facts connecting El Dorado to the negligence claim beyond conclusory allegations and improper group pleading. And plaintiff does not plead facts showing physical injuries as a result from the alleged negligence. Court disagrees. So the court's telling us their conclusion up front. The strongest argument that they have, in my opinion, is the plaintiff does not plead facts showing physical injuries as a result from the alleged negligence. Obviously, the court has to take all the facts as true in the petition or in the complaint, and they do so in this. And so the court goes on to talk about some of the facts that the plaintiff has alleged in this case that support the court disagreeing with the defendants. First, the court addresses the duty of care, which is the first element that we talked about, that the defendants had a duty to create, coordinate, choreograph, block, supervise, direct, execute actions on set to be performed in such a manner so as to make filming and execution of Rust reasonably safe for plaintiff. Another duty is that they had the duty to coordinate, create, execute safety protocols and supervision for filming so as to not increase the safety risks associated with filming the movie. Again, the defendants owed a duty to, without limitation, to reasonably provide for the safety of plaintiff in execution of filming. Obviously, Alec Baldwin owed a duty to others to not harm them, to not put them in a reasonably belief that they could fear that they might be shot. The whole set of Rust also has a duty to make sure that the set is safe and in a manner that would eliminate risks such as this one. The judge goes on to address the second factor, breach of the duty of due care. He states that the defendants breach their duties as described herein by failing to reasonably provide for the safety of plaintiff, failing to supervise, secure, and make safe conditions for the filming of Rust, where deadly weapons were used while filming. Plaintiff also was informed and believes that the cart used for storing ammunition had been regularly left unattended, where people could put live ammunition on it, take away fake ammunition. Plaintiff also believes that loaded firearms had been used by crew members for target practice against safety protocols that should have been in place but were not. So right here, they're saying that these safety protocols should have been in place and they were not, and if they were in place, it would have eliminated this risk. And so it is kind of interesting that other people on the set or even helping out with the movie were firing live ammunition out there while producing this movie. And that would cause some concern because ammunition could get mixed up between live and fake ammunition. And that might have been the case here. We don't know exactly yet. They go on to say that defendants, when they failed to use a professional experienced armor to manage and supervise the use of weapons and instead used defendant Gutierrez-Reed, who was known not to be an experienced armor, which exposed plaintiff to a substantial and foreseeable risk of harm or injury. So how they would really prove that is other individuals testifying against Gutierrez-Reed on how he has been negligent in the past. So that they're going straight after defendant Gutierrez-Reed on that situation. In the second paragraph, nevertheless, it seems like the defense is arguing that because it was a Western film, that they had no responsibility for acting with due care and handling a firearm during the filming, which is a bad argument. And I would not be making that argument to a jury. But this isn't a jury, it's the court. So they can make this argument with no repercussions, really. And the judge says whether demurring defendants acted reasonably under the specific circumstances, including allegations of violations of industry-wide safety protocols for handling of guns on film sets, is ultimately a question not appropriate at the demurrer stage. The court goes on next. Demurring defendants are correct that New Mexico law permits recovery for negligent inflicted emotional injuries only in limited circumstances, and those circumstances require physical injury for negligence claims. That's why I was saying that a physical injury is probably the best bet that the defendants have of getting negligence kicked out, because if they don't have a physical injury, then negligence is kicked. That's the New Mexico law, and that's common for negligence around the country. Here, demurring defendants argue that there are no allegations of physical injuries other than generic serious physical trauma and shock and injury to his nervous system and person. Certainly, plaintiff should have suffered great physical injuries if her body made contact with live ammunition or shrapnel. But demurring defendants overlooked other possible physical injuries, which plaintiff does sufficiently allege under liberal construction of the pleadings of injuries to her ears and head from the loud sound. Accordingly, the court overrules the demur to the third cause of action against El Dorado and Baldwin. So the claim of negligence against Alec Baldwin and El Dorado stands, and it really looks like the judge is hanging its hat on that the plaintiff pled enough injuries so that the plaintiff could continue her case on negligence. With the standard that the judge had to use in this situation and believe the facts that the plaintiff has pled, like he says right there under liberal construction of pleadings, the plaintiff has pled injuries to her ears and head from the loud sound, and so that's sufficient under negligence. And so the judge is going to let this go on for negligence. So the claims that we have left against El Dorado, the company, is negligence, and the claims that we have against Alec Baldwin left are assault, intentional infliction of emotional distress, and negligence. Let me know in the comments what you think about this and if the judge should have done anything different.